A very good afternoon to all my dear student friends. So today we are going to discuss on competition law. So my deliberation will have a structure like this. First of all, I will speak on the introductory part. Then what is the purpose of competition law? For that, I will touch upon the historical overview of the Indian competition law. Then I'll speak for Monopolies Restrictive Trade Practices Act 1969 and the Raghavan Committee report. Then because Competition Act 2002 has replaced MRTP 1969. And what are the anti-competitive agreements, vertical agreements, and in that case, certain terms like relevant market, abuse of dominance, all these things will come. After hearing my deliberation, a student will be able to understand the purpose, the objectives of competition law, will be able to describe what is all about Monopolies Restrictive Trade Practices Act and which has been replaced by Competition Act 2002. And students will also be able to appreciate the different anti-competitive agreements apart from the vertical agreements. And will also be able to explain the different enforcement authorities of competition law. So to start with, giving the befitting introduction, when we talk about competition law, which is also referred to as antitrust law in some jurisdictions, and competition law in fact plays a pivotal role in ensuring smooth functioning of a dynamic market economy. Because competition law takes diverse measures, it takes approaches for ensuring that there should be fair competition among the firms. Because in turn, one can augment customer welfare by offering quality products, not only by offering quality products, but at the same time at the lowest possible prices. So what we are looking for, we always look for the competition, and the competition has to be fair. So fair competition in markets is important for all, whether he is a consumer, whether he is a competing firms or the economy we are talking of. Now coming to the purpose of competition law, the objectives of the competition law. Of course, competition law concerns itself with firms enjoying undisputed market power, which opens up the possibility of hindering consumer welfare. And that is by increasing prices, that is by reducing output, that is by diminishing product quality, or even suppressing innovation. So competition law also keeps a check on the possibility of business firms from colluding with each other and affecting the supply of a product, affecting the supply of a service, depending upon the nature of business in which that particular firm is engaged in, and thereby providing detrimental for the consumers. So the basic assumption is that markets populated by a few may prove to be less competitive than markets housing multiple participants, as we have seen in case of oligopolistic and monopolistic enterprises can also exert their dominance to obstruct, to hinder the entry of new participants. Now, giving the brief history, rather it would be appropriate to say an overview of Indian competition law. The Indian Constitution has been drafted carefully, no doubt about it, with several measures aimed at safeguarding diverse rights, which can contribute to the flourishing of the country as well as its citizens. So we have Articles 38, we have Articles 39, so having been placed in Part 4th of the Constitution as the directive principles of state policy and unenforceable in a court of law have proven extremely significant in laying down directions for good governance of a state. So what they do, they direct the state to frame policies, and the reason being for ensuring that the ownership of the material resources, not only the ownership of the material resources, but all the control of the material resources which are adequately distributed, and that the operation of the economic system does not lead to a concentration of wealth to a common detriment. So the first phase of market regulation in India, it began way back in 1950 to 1951, which was characterized by an increased reliance on the government. More dependency was on the government. Government was to take the initiative in economic activities and are known as the closed economy model. So policies at that time, I would say they were less focused on ensuring competition. They were less focused on in not only on ensuring competition and more on the prevention of concentration of economic power. So the government of India ordered the formation of a committee, and the Mahalanobis committee was formed to assess the income distribution in the society. And when I say income distribution in the society, owing to rising monopolistic trade practices, owing to rising restrictive trade practices in the country. And this led to the formation of Monopolies Inquiry Committee, and the report submitted by the committee, in fact, gave the way for the Monopolies and Restrictive Trade Practices Act 1969. In short, we call it as MRTP Act. This way, the Constitution of India, specifically Article 39, showed the seeds of the genesis of competition laws in India. Now, coming to the Monopolies and Restrictive Trade Practices Act 1969, in short, we call it as MRTP Act. The act was, in fact, enacted to control monopolies, to ensure that the economic system does not culminate in concentration of economic power, and to disallow monopolistic trade practices and to disallow restrictive trade practices. So, what lighted the second phase, that starting from 1991 till date to present time, was bringing forth the market-oriented economic policies with the coming of the new economic policy, because the new economic policy that needed to be in tune with the rise of globalization, because as you all know, the globalization started way back in 1991-92. The globalization, rise of liberalization, rise of privatization policies. And these policies led to what? These policies led to delicensing of sectors. These policies led to deregulation of sectors that were priorly, I would say, under the control of the public sector. So we had industrial activities, and industrial activities which were exclusively operated by the public sectors, they were opened up for entry by the private sector. So MRTP Act was observed to be incompatible with this shift in industrial policies, because industrial policies which focused on competition, which focused on market orientation, thus rose the necessity, the need for the regulator which could facilitate market functioning in accordance with the country's changing industrial policies. So Raghavan Committee, which was formed, and when we look at the report of Raghavan Committee, the call seeking a shift of focus from restraining monopolies to the promotion of competition. That was one of the primary reasons for the MRTV Act becoming obsolete. And in fact, it was choking the economy. So, thereby giving way for a new legislation, paving way for a new legislation. What ensued was the appointment of high-level committee on competition policy and law in 1999, often referred to as Raghavan Committee. The committee was responsible for providing suggestions for the establishment of a suitable legislative framework for competition law and recommendation changes in relation to restrictive trade practices. So that is how the committee in its final report submitted to the government in May 2000. And the committee highlighted the necessity, the need for a competition policy to attain efficient allocation of resources, to regulate concentration of economic power, and to promote consumer welfare. So these three was the necessity, and it was all submitted that the competition policy has its own primary economic goal as the preservation of competition, as the promotion of competition, which can further contribute in making the process of production, in making the process of allocation of goods structured and more efficient. So the committee, based on the need to balance, to strike a trade-off between the conflict between the existing government policies and the competition that we are talking of, the competition policy, and highlighted the requirement for a law and a law enforcement authority in the form of Competition Act. So that created Competition Commission of India. It is normally referred to as CCI commission. Whenever we utter the word, normally we utter the word commission, but it is understood that Competition Commission of India. Now coming to the Competition Act 2002, the Competition Act was enacted in 2002. And the Competition Act, when it was enacted in 2002, the act was enacted based on the recommendation of the Raghavan Committee. The very purpose, as I have been telling you all this time, that for ensuring fair competition and ensuring economic development in the country. So the primary aim of this piece of legislation is to avert practices, some kind of practices having anti-competitive effects for the advancement of competition in the markets and to safeguard the interests of the consumers who are the beneficiaries and to guarantee freedom of trade to the market participants, to different firms. So this legislation is the successor to your Monopolies and Restrictive Trade Practices Act 1961. So the Act lays down provisions relating to horizontal agreements, relating to vertical anti-competitive agreements, horizontal anti-competitive agreements. And because they were all having an adverse effect on the competition, and that is why prohibition of abuse dominance was there, and having the rules for combination of their regulations for necessary enforcement. So the Competition Act also contains certain provisions to promote competition advocacy. Now coming to the anti-competitive agreement, obviously the agreement we are talking of entered between enterprises, agreement we are talking of entered between persons, agreement we are talking of entered between associations of enterprises or the persons in pursuance of production, in pursuance of distribution, in pursuance of supply, in pursuance of storage, in pursuance of control of products or services. depending upon the nature of business in which that particular firm is engaged in, and which have a tendency to result in appreciable adverse effect or competition. So this is within the jurisdiction which are referred to as anti-competitive agreements, and they shall be declared as void. So to determine if an agreement you have gone for has an appreciable adverse effect on competition, obviously the Commission shall have due regard to factors including creation of barriers to new entrants, driving up existing competitors, or foreclosure of competition by obstructing, by hindering entry improvement of production, entry improvement of distribution of goods, etc. So in a competitive market setup, farms vying for the businesses or the consumers are supposed to compete with one another and not to collude and cooperate to alter the process of competitions. So cartels are horizontal agreements made for the purpose of market allocation, made for the purpose of price fixing, made for the purpose of output restrictions, made for the purpose of, you can say, submission of collusive tenders to rig the outcome of competitive tenders. They are some of the techniques normally employed by conniving firms to disturb competitions. So under the Competition Act 2002, and that too, if you are talking of Section 2C, puts forth an inclusive defining of cartel as association of producers, and the sellers, association of sellers, even association of distributors, even association of traders, even association of service providers, who by some kind of agreement among themselves, they limit to the production, they control the production, they make an attempt to control the production, and they control the distribution, they control the sale or the price out or the trade in goods or the provision of services. So in the cartelization by public sector insurance companies, the case, the CCI, Competition Commission of India, took so much of cognizance and engaged in bid rigging in response to a tender issued by the Kerala government. So rejecting the argument of the insurance company that they formed a single economic entity, were thus subject the control of the central government. So the CCI held that the submission of separate bids by the companies for the bidder, along with the resolution regarding determination of bid amounts being taken voluntarily, though an internal meeting without the supervision by the finance ministry, proved the contrary. Based on the business sharing agreement, and you can say the evidence of the opposite parties having met one day before the submission of tender. So Competition Commission of India held that there was a conclusive proof of bid rigging and collusive powers by the, you can say, opposite parties. So in this case, these are all for the purpose of satisfying the requirements for contraventions under Section 33D of the Competition Act. So any agreement normally which are entered, or the decisions which are normally taken amongst enterprises, among the persons, among the association, among the any between two persons, between two enterprises, including cartels, shall be presumed to have an appreciable adverse effect on competition and shall be considered anti-competitive for anybody. So if they result in the determination of sale price. So when we are talking of the determination of the sale price, the competition regulatory framework not only concerns itself with blatant price fixing, but also some kind of agreement having an effect on suppressing price competition. In other words, if I put it, the act of price fixing doesn't just encompass the final price, but also instances are there having an indirect impact on the final price. So now, reducing the price competition by agreeing not to offer discounts or making use of an open information scheme and charging some kind of uniform delivered price may also be instances of price fixing. Your market participants forming a cartel, agreeing to offer identical discounts, and applying the same in the downstream market was also another facet, held to be another facet of price fixing and declared to be anti-competitive in nature. Now coming to the output control, an agreement among the firms to control or to limit production, to control supply or to limit supply, or to control technical progress or limit technical progress, or to control markets or to limit markets, or any kind of provisions of goods and services shall be presumed to be anti-competitive. That is why Competition Commission of India, in short CCI, generally focuses on factors such as production capacity, factors such as capacity utilization of the competitors, factors such as demand for the product in the question that is being put to the consumers, and the to all these things to decipher any patterns of output control for the concerned product. So in the cement cattle, the commission found evidences regarding the formation of understanding, formation of agreement among the opposite parties, that is by a cement manufacturing association, for communicating for information sharing in relation to manufacture of cement. So the commission also honored low capacity utilization leading to controlled supply of cement by the companies, and this was in clear contravention of the section 33 of the Competition Act. The commission opined that limiting the supplies of cement over the course of years and giving rise to the shortages which had led to an upward demand, resulting in a high in price thereafter. So in the absence of any efficiency or any improvements in the manufacture owing to the coordinated behavior of the cement manufacturing companies, the opposite parties were held to have formed a cartel. So recently the CCI, Competition Commission of India, passed a final order against these three beer companies: United Breweries Limited, Sub Miller India Limited, renamed as your Onesure Goose InBev India Limited, and the cartel, your India, that is your, you can say, Carlsberg India Private Limited, for forming a cartel and selling beer in many states and many union territories, that is in injunction with the All India Brewers Association. So the cartel, you can say, had engaged in your price parallelism, which was in contravention to, you can say, which was in contravention of section 3 of A of the Competition Act 2002. And now, coming to the market allocation, obviously the market allocation, when we are talking of, that may also be threatened by an agreement. And this agreement between the firms to apportion segments of the market amongst themselves, which is to be handled exclusively by each seller, so that they no longer have to compete with each other. So when participating firms occur to share what? Share particular markets. How that is done? Based on geographical area, based on classes of customers, based on the basis of the product, such as agreement, which may be referred to horizontal market sharing agreements. In horizontal uh, sharing market, uh, one thing that is needed, the opposite parties were penalized for forming a cartel and indulging in sharing the entire uh, European market among themselves. So they further engaged in and um, acts to obstruct, hinder the only substantial competitors not forming a part of the cartel, that is driving it away from the concerned market. Now, the fourth one, that is your bid rigging or the collusive bidding. Any sort of agreement you might go for that is capable of lessening competition, that is capable of wiping off competition for bids, or which have the effect and uh, the effect of manipulating the process of bidding. They are all held to be anti-competitive versus bid rigging or collusive tendency is said to be is said to occur when competing bidders they decide not to compete genuinely and always endeavor to secretly influence the outcome of the bidding process. This is done by submission of identical bids or the cover bids. So in case of catalyzation in tenders of Pune Municipal Corporation for solid waste processing, the prima facie, you can say, the prima facie opinion was formed by the Competition Commission of India against opposite parties for having engaged in the arts of bid rigging, engaged in the acts of collusive bidding violation, thereby violating the section 3 of 3D of the Competition Act 2002. So the CCI, Competition Commission of India, uh, opined that the bid rigging under section 33D shall be uh, presumed to have an adverse effect on the competition, irrespective of the purpose, irrespective of the duration of the cartel line. So it material, rather to be more specific, if the act culminated in a benefit being accrued from the cartelization. So since the Competition Commission of India, uh, when we are talking of, obviously, we look at the CCI opined that the bid rigging under section 33 of D shall be presumed to have an adverse effect on the competition, and that is irrespective of the purpose, that is irrespective of the duration of your from the cartelization. So Competition Commission of India has also held that so long as a subset, so and in all these cases, the uh, thing has to be seen that the Competition Commission has to see that there should not be any kind of rigging the bid. So the benefits accrued should not be cultivated, or the material, since we look at the section under section 33D of Competition Commission of India opined that the bid rigging under section 3 of 3 of D shall be presumed to have an adverse effect on the competition, that is irrespective of the purpose, that is irrespective of the duration of the cartel, and it is quite material if the act culminated in a benefit being accrued from the cartelization. And the Competition Commission of India also held that so long as a subset of bidder are found rigging, the rigging process by colluding or the owners shall shift on the opposite parties to rebut the presumption having caused the aspect. So disagreeing with the contention of the opposite parties that they were all engaged in different business activities at the time of the bidding process, and thus they're not amenable under Section 3. The Commission held that the activity, you can say, the activity for which bidding was held and the in pursuance of which there may be alleged violation of law, and that took place and which proved significant in determination of cartels. Now, coming to the vertical agreements, the vertical agreements are the agreements which are made between the persons. These are the agreements which are made between the enterprises at different levels of the production chain in distinct markets, and that too in relation to production, in relation to distribution, in relation to supply, in relation to storage, in relation to price of the goods, or any kind of provisions of services, if at all is there. So unlike horizontal agreements, vertical agreements are not anti-competitive, but rather it needs to be established that the alleged activity has caused an appreciable adverse effect on your competition which is happening in the country. So vertical agreements also needed in certain cases. The case could be there could be a tie-in arrangement. That means tying is the practice of supplying a product and the tying product while also making the buyer purchase a second product known as tied product. So tying may be employed by the dominant firm, no doubt about it, for increasing its sales of the tied product in the market, and this is possible by leveraging its position with respect to the tying product and leading to a horizontal foreclosure of market. So a tie-in arrangement is detrimental for competition as the consumer is forced into purchasing a product. So this is a kind of manipulative way of influencing the consumer for purchasing a product that is tied product, which he may not necessarily require. So in Hilti AG versus Commission Tetra Pak, a company engaged in the sale of liquid packaging machines required customers to also buy your cartons from it, and further insisting that services for repair, services for maintenance should be provided by, you can say, them. So the commission opined that the sale of cartons along with the machines was not customary with the proper forming a separate market upon which Tetra Pak was trying to eliminate competition. So now the another aspect that is the which you speak for the vertical agreements, that is your exclusive supply agreements, because agreements restricting the buyer from purchasing goods, agreements restricting the buyer from purchasing services other than those of a particular supplier, they are all termed as exclusive supply agreements. So such agreements can also be referred to as your exclusive purchasing or single branding agreements. So the by employing such agreements, the purchaser is barred from acquiring products because from other competing, you can say, perhaps the same seller will also be there, and the purchaser is barred from acquiring products from the other competing sellers, so defeating the process of market competitions. In Jindal Steel and Power Limited versus Steel Authority of India Limited, it was alleged that the agreement between Steel Authority of India Limited and the Indian Railways for exclusive supply of rails to IR, that is your industrial relation, and was anti-competitive, resulting in foreclosure of the market for new entrants. So, including Jindal Steel Works, the commission also, you can say, also held that the exclusive arrangement between the sale and your IR was not in violation of the provision of the competition law, as only a small segment of sale. That is how the total sales made up of the sale of your IR, and also IR required to uh, have some kind of assurance for steadiness of supply of long rails, which was being offered by SAIL, and with Jindal having failed to establish itself as a viable competitor to SAIL. So in this case, one another situation will come, that is your exclusive distribution income, because in case of exclusive distribution agreements was requiring that the supplier to sell its goods to one specific distributors, and that too in a particular territory, so thereby restricting and output maybe or supply of any products that will fall under the category of exclusive distribution agreements. So this may diminish intra-brand competition, and this may heighten the risk of the market. And this you have to take as challenge partitioning or market allocation for the sale of goods, facilitating your price discrimination. Another is your refusal to deal. When I talk about the refusal to deal, it refers to some kind of scenarios where the restrictions are placed on persons, restrictions are placed on classes of persons to whom goods may be sold or from whom the goods may be bought. But having said that, the refusal to the deal agreement result in market foreclosure for new entrants, and making it uh, difficult for the latter to compete. So English Wales and the Scottish Railway Limited, uh, the railway, uh, you can say, company was fined for entering into exclusive agreements with various power stations for the cartel of coal. So now another thing which will come, that is your resale price maintenance. So resale price maintenance occurs when the seller, mostly the manufacturer, mostly the manufacturer, what they do, they demand that the buyer, who are the buyer, mostly they are the retailers, they should engage in resale of that good only at a price which is fixed by the seller. And in this case, the buyer cannot resell at prices lower than the prices which are suggested by the seller. So in FX Enterprise Solutions India Private Limited versus Hyundai Motors India Limited, the Competition Commission of India, the CCI, found that Hyundai Motors, they were placing restrictions on its dealer. How they were placing restriction on its dealer? By imposing a maximum permissible discount at which the vehicles may be sold to an end consumer. So those dealers not adhering to the upper limits on the discount prices were being penalized. So matter came. So CCI held that the imposition of the minimum resale price prevents the dealer from effectively competing on the price factor, as a result of which that is anti-competitive in nature. So Section 3 of 5 of the Competition Act holds that such type of agreements shall not affect the rights of any person to restrain infringement or from laying down some kind of reasonable conditions imperative to protect her intellectual property rights, including your patents, including your copyright, including your trademarks, including your designs, including your geographical indications. Now, coming to the relevant market, under the statutory framework of the Competition Act, The delineation of a relevant market is of utmost significance, I must say. For an abuse of dominance investigation, an enterprise shall be considered dominant only if it has attained a position of strength, that too in the relevant market. So determination of relevant market is also significant, that too in a combination analysis, where the Competition Commission of India has to ensure that the proposed combination does not result in appreciable adverse effect on competition. But in case of Competition Commission of India versus Coordination Committee of Artists and Technicians of West Bengal Film and Television Industry, matter went to the Supreme Court and heard by the Supreme Court. The Supreme Court had held that the delineation of relevant market is not a necessary precondition. Necessary precondition for your investigation under Section 3 of the Act, as there is presumption in an agreement between market participants under that particular provisions. So, relevant market may be determined by the Competition Commission of India with respect to the relevant product market, or the relevant geographic market, or with regards to both. So, relevant product market is referred to as the market with products, is referred to as the market with services. Those products and services which are considered interchangeable, those are considered which are substitutable by a consumer due to the factors such as the characteristics of the product, the characteristics of the price, or the utility. So in the case of in rematrimony.com and the Google was also charged with abusing its dominant position and thereby granting preference to its own services and its vertical by manipulating the search results. So the relevant market in this case was delineated to be the market, and the market for online web search services in India and the market for online search advertising in India. And this was done by differentiating, and the differentiating was made between offline and online section of the advertising. On the basis of that, they are not substitutable. So relevant geographic market is referred to a market which is comprising the area where the conditions of competition, maybe for supply of goods or the provision of services, they are distinctly homogeneous and can be differentiated from the conditions existing in the adjacent areas. So in Harsita, Chawal and others, since conditions for the functionality of the message application through smartphones were found to be homogeneous throughout India, and the entire geographic region of India was also delineated to be the relevant geographic market. Now, coming to the abuse of dominance, under competition law, mere dominance, if it is exerted by a firm, is neither considered bad nor held punishable. But however, the abuse of its dominance, that too by an enterprise, merits investigation by the competition authority. This is in contrast with the earlier legislative framework as under US Trial MRTP Act, violation of judged based on the size of the enterprise rather than abusive conduct of the enterprise. So an enterprise is said to be in a dominant position when it is able to operate independent of other competitive forces existing in the relevant market, and the enterprise has the power also to affect the consumers. Enterprise has the power also to affect its competitors in its favor. So competition law abuse makes abuse of the dominance by an enterprise punishable under law. So some of the acts considered to be an abuse of dominant position includes imposing of conditions or imposing of prices and those conditions which are unfair, those prices which are unfair, or there will be discriminatory or prices, or the conditions, there is discriminatory conditions either through direct or through indirect means, which includes your price discrimination or predatory pricing, and restricting the production of goods and restricting the provision of services. So the commission seeks to capture conduct which may be exploitative, wherein the acts of the enterprise prove detrimental to the consumers in the form of a rise in prices, or the form of reducing the output, or the form of imposition of other unfair terms and conditions. This is exclusionary, that means affecting the competitors of the dominant firm through acts of exclusive dealing, exclusive uh, margin, or exclusive squeezing, or exclusive denying market entry to a new firm which are coming. So what happened in case of Google, European Union versus Google, also known as Google search shopping case? Google was fined 2.42 billion. Uh, uh, that was uh, dollar by the European Commission by for abusing its dominance in the general search market, and stifling market competition by granting primacy to its own vertical comparison shopping services. And finally, matter was hard, and it was held that the Google's self-preferencing conduct had foreclosed competition in the shopping services market, which represented a separate market from the search market. So, leveraging its position in the general search market, Google had resorted to bumping down other rival sites down the list, and thereby distorting competitions. So there are three important steps normally required in every abuse of dominance investigation. The first step is that you have to determine the relevant market, and the second step is that you have to determine if the enterprise is dominant in the relevant market or not. And the third step, if at all found dominant, then investigation should continue investigating whether the dominant entity has engaged in facts falling under the purview of abuse of dominance or not. So CCI, Competition Commission of India, while inquiring into the dominance of an enterprise, shall also consider one thing: the factors. What are the factors? The factors provided under section uh, 1904 of the Competition Act, which include market share, which include market size, which include market resources, apart from countervailing buying powers, market structure, and the dependence of consumers. So, Section 4 of the Indian Competition Act also takes into account the use of the dominance in one market to enter into another and relevant market. So, in the case of your horse chawala and WhatsApp, the issue was whether WhatsApp was using its dominance, or you can say it is not. So the fact remains, the issue whether WhatsApp was using its dominance in the relevant market of the market which is of internet-based instant messaging applications are there to, because to gain entry to another relevant market, being unified payment interface, digital payment system application market, which was aided by pre-installations of what WhatsApp or any mobiles they do. So the commission post investigation held made that there was no abuse of dominance as the users were allowed discretion before users of the payment application along with separate registration requirements, where you have also terms and conditions prior to initiation of services. Now coming to the merger and the acquisition part, obviously what we look at that the merger taking place, acquisition taking place, which is one of the significant business development in the field of corporate law, has been a plethora of transactions encompassing mergers and acquisitions. The rationale behind companies opting to merge may range uh, from increasing market power, increasing market economies of scope, or increasing economies of scale, or synergistic gains, or eliminating competitions, or to obtaining access to research and development apart from the technological know-how. So competition law is entrusted with the task of scrutinizing mergers that have a potential for undermining competition. So while assessing a merger, so when we go for assessing the merger, the competition authorities, they investigate if the merger will generate horizontal effects. That means effects born out of mergers between actual competitors or potential competitors at the same level of the production chain, and they are all dealing with the same product. They are all dealing with the same geographic markets. Uh, uh, and the vertical effects, the effects occurring as a result of merger between enterprises operating in different, albeit complementary stages or levels in the market for the same final product, or there is conglomerate effects, that means effects originating due to mergers, which is neither functionally vertical nor horizontal, but enables the merged entity to foreclose the competition, and that too in two distinct but related markets or unrelated market, and that is possible by exercise of its market power. So in the merger, we have merger control as a means to keep a check on the market power of dominant firms on an ex ante basis is essential also to preserve competitiveness or to preserve competitive market structure for achieving pro-competitive effects for the consumers. So a complicated element of merger control is that its role is forward-looking in nature, focusing on whether a proposed merger will lead to detrimental effects on the competition in the future. Numerous theories of competitive harm have been um, brought forth to highlight the negative impact of a merger on the consumer welfare, which includes your unilateral effects, that means resulting entity of a merger exercising market power post merger, including your coordinated effects resulting entity of a merger able to harmonize competitive behavior with other firms in the market, or the vertical effects or the conglomerate effects, because competition authorities, they conduct merger assessment by making an an assessment, merger assessment, by weighing the pro-competitive effects of a combination on the market against the anti-competitive ramification if the merger is allowed to be consummated. So under the Indian Competition Act, Section 5 and Section 6, which are the significant provisions regulating combinations encompassing corporate structuring methods such as merger, acquisition, and amalgamations. So according to these provisions, enterprises or the persons, those choosing to enter into combinations and crossing the specified assets, crossing the specified turnovers, your these um, uh, which are there in the section 5, have to inform the Competition Commission of India divulging the details of the proposed combination. So combination likely to result in an spectrum within the relevant market shall be void in accordance with section 6. So there are various factors providing guidance to the Commission for approving or rejecting a combination or given under the Section 20 of 4 of the Competition Act, and it includes factors such as the extent of barriers, um, or the extent of countervailing power present in the market, or market share of the enterprise, or the presence of substitutes, whether available or not. The notifications are handled with reference to the procedure in regard to the transactions of business relating to combination regulations 2011. So within 210 days after the notification, the proposed combination gets served. So CCI, the Competition Commission of India, performs analysis if the combination causes, or the combination is likely to cause, either it causes or is likely to cause some kind of appreciable adverse effect on the competition, which is done based on the factors as per the Section 20 of 4th of the Competition Act. So the assessment of the significant may arise as a result of the combination, and subsequent decision in case of the former can also be assumed by the remedies or the notifications termed as modifications. So under the Act, modification may be suggested by the Competition Commission of India or either the parties, who can also propose the changes to be made, changes to be to the suggested modification in order to bring about some kind of mutually workable feature within the specified time. So merger modification rather than outright rejection is slowly gaining momentum for resolving combination issues and threatening to disturb the status quo, the existing position in the market framework. Now, coming to the enforcement part of the competition law, the Competition Act also provides a multi-tiered enforcement mechanism. As per the provision of the Competition Act, Commission can inquire into any alleged infringement of Section 3(1), Section 4 of 1 of the Competition Act based on its own motion, or on the receipt of any information given, provided by the reference received from the central government or the state government or any statutory authorities. So, under the statute, there is no locus standi requirement, but the CCI, Competition Commission of India, after the receipt of the information, is expected to satisfy itself to the existence of a prima facie case and pass direction to the Director General under the Section 26 of 1 for initiating investigation. So we have Director General, in short we call DG, is bound to assist the Commission while conducting the investigation for any kind of infringement, for any provisions, infringement of any rules, infringement of any regulations, if at all made under the Competition Act, for which DG shall be empowered with all kinds of power normally conferred on the Commission by the Act. Where the Commission considers that the prima facie case exists, it directs, in fact, the Director General to investigate the matter. So the Competition Commission of India, the Director General conducting investigation, he has to submit his findings to the Commission. The Commission, based on the findings of the Director General, may either choose to close the matter or pass such orders as it deems fit. So if you are not happy, then there are appellate authority. Appellate authorities are there, national company law, appellate tribunals, which has been designated as the appellate tribunal for handling the appeals arising from the Competition Commission of India. So the appellate body has been empowered to hear the appeals, to dispose of the appeals against any order, direction, against any order, direction, or the decisions even issued by the Competition Commission of India. And additionally, the National Company Law Appellate Tribunal has been empowered to adjudicate the claims for compensating for the any kind of findings of the Commission, as well as passing of order for the recovery of compensation also. So in all these cases, the appellate tribunal need not be bound by the Code of Civil Procedure 1908, but must conform to the principles of natural justice while conducting its procedure. So the conclusion would be that the competition law is an economic legislation of immense significance today, and it plays an important role in managing the dynamics of the market. So the kind of provisions related to anti-competitive arguments or the abuse of dominance or combinations, they always help to ensure how we can have fair competition in the market and thereby augment consumer welfare. So today, with the rise in online platforms and the rapid shift to e-markets, competition authorities also forced to recognize the significance of non-price parameters of competitions like your quality aspect, like your innovation, like your privacy. So what I mean to say that ensuring fair competition in digital market also poses for far more challenges for the competition enforcement authorities, in fact, as compared to the traditional market. But the dynamic character of the market and the constant emergence of new challenges also, I must say, make competition law one of the most interesting areas of law for the students as well as the practitioners. With this, we come to an end of today's deliberation. Thank you very much. Have a nice time. Good day.